Hello, class. This particular tape is going to deal with Chapter 5, Interrogation and Torture. A very interesting chapter. I'm going to focus on this tape just on the interrogation aspect, but I do want you to make sure that you read closely the pages on torture and extreme rendition, etc. And if you have any questions, contact me. But I do want to talk about interrogation because it's very important, and this is one aspect of the chapter that for those of you that are either working in the field or that might someday go into the profession, it could have a real profound impact on you doing your job. As we know, interrogation and torture are two of the most hotly debated issues in the law of terrorism. And so to address that and link interrogation to the law of terrorism, what we need to do is take a look at the law of interrogation itself and how it's evolved in the United States. And I want to talk about a couple of cases that are mentioned in the book here and give you a little bit of a foundation. Just remember that interrogation is important in any criminal investigation. Obviously, the police always want a confession that's freely and voluntarily provided, not through torture. But the confession is important, but it becomes even much more important in a terrorism case, simply because not only do we want a confession, but we also want to obtain intelligence and information that could stop a future attack, could identify other terrorist cells, and lead or assist the government in dismantling a terrorist organization that may be operational. The Fifth Amendment provides, and you guys should have studied this in your criminal law and criminal procedure classes, so I'm not going to spend a lot of time on this explaining it, but the Fifth Amendment has one element of the Fifth Amendment, probably the most important element of it, is the right to self-incrimination. In other words, a person doesn't have to testify against himself, and that's where interrogation comes into play. And this was codified in the Bill of Rights, and it took a long time in our nation, really, for some aspects of the Bill of Rights actually to appear into our criminal procedural law. As you know, the Bill of Rights only applied to the feds, and it took the 14th Amendment and the Due Process Clause itself within the 14th Amendment to actually make most of the, to actually make it applicable to the states as well. So let's look at a couple of Fifth Amendment cases that are real important. And of course, one that all of you are familiar with is the 1966 case of Miranda versus Arizona. And in this case, which was a very hotly contested case, the vote was 5-4. Ernesto Miranda was interrogated and provided a statement, and ultimately the end result, without going into a lot of details, the end result was the court realized that if there are two triggers, the court ruled in the favor of Miranda, even though when they went back to trial he was convicted, but the confession could not be admitted. And in their ruling, the court established what we call the Miranda rights, something that we're all familiar with it. And Miranda is built on two triggers. And those triggers are, number one, custody, if a person is in custody or been arrested. And number two, if he's interrogated, he or she, and asked questions about the crime for which they're under suspicion. If these two triggers are met, then a law enforcement officer must provide the Miranda warning to a suspect. The suspect must acknowledge, either verbally and in writing preferred, that they understand their rights and that they agree to answer questions or waive their rights to answer questions asked. If those two triggers are established and a law enforcement officer does not provide Miranda, in most cases, except for a few exceptions, one of which we're going to talk about here shortly, then the confession itself, if it's provided, will be suppressed and it will not be usable in court against the suspect. Now, about 18 years after Miranda, another important case emerged that's pertinent to what we're going to talk about in this chapter, and that's Quarles versus New York. In this case, the Supreme Court established the public safety exception to the requirement that Miranda be provided to an individual who's in custody and being questioned. In that case, a woman had told police officers that she'd been raped. She gave a description of the assailant, said the assailant had a gun, and he was had fled to a particular supermarket. When the police entered the supermarket, they located the assailant. They did a stop and frisk. When they patted him down, they found his shoulder holster, but they couldn't find the weapon. They then asked him, they didn't Mirandize, and they asked him where the gun was, and he took them to that location. The issue that was ultimately decided by the courts was, and of course in this case Quarles argued that his confession that he did have a gun and taking them to where the gun was an admission on his part, should be suppressed and not allowed because the police did not Mirandize him before they asked him that question. But what the court said was, in this particular situation, and they actually have they created a judicial exception to Miranda, which they call the public safety exception, and we conclude that the need for answers to questions in a situation posing a threat to public safety outweighs the need for the prophylactic rule protecting the Fifth Amendment privilege against self-incrimination. So in that circumstances, the needs of society to be safe overrode the individual needs of this individual to be provided his rights relative to self-incrimination. And the public safety exception can apply in a lot of different ways. It can apply in bank robberies, dealing with gang members, dealing with weapons and knives, and also where it's important is relative to terrorism cases. And this is where what they call the ticking bomb situation, where is what if the police pick up a suspect who's a terrorist and they have reason to believe that he has a bomb that he's going to detonate in the city somewhere. Do they need to Mirandize him, or does the public safety exception rule apply and they are authorized to question him without Miranda in hopes of finding out where that bomb is located? That is the key issue relative to terrorism, and they address it in several cases in our textbook. Now, there's a couple of cases they mentioned. These are pre-9/11 cases. The United States versus Colon Osorio. In that case, the police did question an individual relative to a bombing and weapons, and if the individual is under control and there really isn't a public safety situation at that time, the courts are not going to allow the government to claim the public safety exception rule in those cases. And they talk about it with the Colon Osorio case. Also, there's another case, the State versus Kane. So make sure you look at those, because the distinction there is, hey, if the police have a person under control and they don't have access to a weapon or something like that, there are times when the courts might not agree to this public safety exception. But there are other times that they will, and there have been multiple occasions when they have approved it. There's one that they mentioned in their United States versus Dodge, which is a Ku Klux Klan case. The two major cases that I want to mention that they talk about here in the book, let's look at the Umar Farouk Abdul Muttalab. I'm going to call him the underwear bomber, or the Christmas Day bomber. That's another term that they used for him. He attempted to, he was on a flight from Amsterdam to Detroit, and he was an international terrorist. He had secreted a bomb in his underwear. It's an interesting story as to why the bomb didn't actually detonate, and the word was that he had worn that underwear for like either a week or a couple of weeks, and it soiled, and I guess the bomb itself degraded to the point where it wouldn't go off. But anyway, he tried to detonate it on the flight. Thank God it didn't go off, and he was arrested when he arrived in Detroit by the FBI. The FBI questioned him for about 50 minutes without providing him Miranda warnings. During their questioning, he had suffered some burns when the device did not activate fully, and He made a number of incriminating statements, including telling officers who were guarding him that he had acted alone on the flight. He did intend to take the airplane down. He had tried to trigger the bomb. That's what he told a physician who was treating him because of the fire in his groin and on his legs. And so bottom line is that during those 50 minutes, he was not providing Miranda, and he did provide incriminating statements. Ultimately, he was medicated, but not to the point where the officers felt that he was not capable of answering questions or cognizant of his surroundings. And at that point, they did provide him Miranda, at which point he would not waive his rights and refused to answer further questions. Now, the Department of Justice became under great criticism for even Mirandizing an individual who's not even an American citizen based on this situation. Nonetheless, when he goes to court, obviously they try to get the statement suppressed. And in this particular case, the court did rule that the public safety exception did apply and that the actions of the FBI were lawful. Again, the critic argument is, why are we even giving these people Miranda? We should be worried about national safety, not the individual rights of a foreigner. But at the time this happened, the officers, the agents were following the procedures the FBI had established in those situations. In the case they talk about in the textbook, also that's important, and that's the Faisal Shahzad, the Times Square bomber. He tried to detonate a vehicle-borne improvised explosive device in Times Square during the Christmas season. Fortunately, the device did not go off. He was arrested. He also was questioned for a time period, trying to see if there was any, the key to this questioning is, especially with guys like the underwear bomber or the Times Square bomber, is how do we know when we first pick him up that there's not other individuals involved and other simultaneous attacks? How do we know there's not somebody else on another plane doing the same thing? So that's the justification and the reasoning that goes behind, hey, let's question these people. Let's don't advise them of the rights at this point, because if they shut up, if they don't respond, if they don't agree to waive their rights, then we might not hear about another threat that's ongoing. That's the legal rationale that's used. In the Shahzad case, he was arrested while boarding. He had parked the vehicle. It was supposed to go off with a timer. He actually was trying to flee the country, and they caught him at JFK Airport trying to get on a flight bound for Dubai. He made a number of incriminating statements also to the police, and then he was advised of his Miranda rights, and he actually waived his Miranda rights and did agree to talk. So it's been my personal experience. A lot of people think that when you Mirandize somebody, they're not going to talk to you. Sure, there's some hardcore criminals out there that won't talk to anybody, but my experience has been that most people and I've conducted hundreds of interrogations, even though you provide them a Miranda warning, they will talk to you. So again, the Department of Justice is using the Quarles decision to justify their questioning of terrorists prior to Mirandizing them because of the public safety exception. In fact, after these two cases, if you look at page 264, excuse me, of your textbook, the FBI actually updated their procedures relative to similar situations with terrorists like this and their questioning. Initially, they wanted Congress to pass a law, but Congress never did follow up. So the FBI went ahead and issued memorandum, and basically what it says is, if applicable, agents should ask any and all questions that are reasonably prompted by an immediate concern for the safety of the public or the arresting agents without advising the arrestee of Miranda. And after all public safety questions have been exhausted, they then should advise the arrestee of Miranda. And there may be exceptional cases in which, although all relevant public safety questions have been asked, agents nonetheless conclude that continued unwarned interrogation, unwarned being no Miranda, is necessary because they need to collect valuable and timely intelligence not related to an immediate threat. Now, this memorandum goes on to state that in circumstances surrounding the arrest of what they call an operational terrorist, this is the procedures they should follow. Now, in those cases where they're going beyond the public safety and they're trying to gather intelligence, they should seek approval from their supervisor, who should consult with FBI headquarters and the Department of Justice whenever feasible. Now, the FBI's new policy as to the writing of this textbook has not been challenged in court. So until that happens, that is the procedure that they will follow in dealing with terrorists that they capture that are operational, similar to the underwear and the Times Square bombers. Now, there's a couple issues I want to talk about that I think are important also relative to interrogations abroad. Now, you remember the Eunice case. We talked about that, I believe, in Chapter 1. He was the individual that was involved in a hijacking of an airplane, the first effort by the United States to use the extraterritorial application and go over there and arrest him. They lured him into the Mediterranean, and once they got him into international waters, they arrested him, put him on a ship. They interrogated him as well, but they actually Mirandized him. He waived his Miranda rights. Ultimately, he filed complaints because they interrogated him, I think the textbook talks about 4 days, 9 hours a day, and he did provide incriminating information. And one of his issues, he had become injured in the actual arrest, and he filed some complaints about custody and the fact that he'd been injured. Therefore, the waiver was not voluntary. He complained that while he was being questioned, he had nausea, dizziness, exhaustion. What was interesting is the trial court, the district court that tried him, actually suppressed his statements. In other words, they felt that he was not in condition to voluntarily provide a confession. However, on appeal, the D.C. Circuit Court, which would be the next level up, the appellate court, found no constitutional violation, concluding that his Miranda waiver was knowing and voluntary. And they talk about that in a little bit more detail in the book. Another case I want you to review also is the United States versus Youssef. There's an interesting discussion there relative to Miranda and his suspect in the First World Trade Center bombing. But one of the key discussion here in this element of the chapter regards interrogation on foreign soil. As our textbook says, the law is settled relative to legality. The statements taken by foreign police. Let's say you have a foreign suspect, an international terrorist, and let's say the Egyptians are questioning him relative to a crime that may have an impact on the United States. Statements that are taken by the foreign police without the presence or the input of American agents are admissible if they are voluntary. So the whole question will be the circumstances. If the American government, if they try to prosecute a terrorist based on statements he made, say, to the Egyptian police forces, if they can show that the statement was voluntary, in other words, they didn't beat him or whatever, then that statement is admissible, absent any Miranda warnings. However, they did establish the so-called joint venture doctrine during overseas interrogation by foreign police when United States law enforcement agents actively participate in the questioning conducted by foreign authorities. So let me give you an example. If the Egyptians are interrogating a foreign suspect relative to an attack planned on the United States, and the FBI is participating in that discussion, then that individual has got to receive the Miranda warnings. If not, then that statement will be suppressed. And that's called the joint venture. Joint being American agent and a foreign police officer. So the joint venture doctrine becomes a trigger for Miranda in that foreign environment. There's also some interesting discussion in that 1993 case too as well about the Miranda warning form that they use. They call it the AOR. So make sure your advice of rights form. So make sure you read that. But anyway, I'm going to wrap this tape up because I've already been talking for 20 minutes and I know your time is valuable. The domestic interrogation of foreign nationals is very interesting. It's interesting law. And just remember that public safety exception decision is very important. So Miranda and the Quarles case are very important cases and decisions relative to situations involving individuals like the underwear bomber and the Times Square bomber. And that'll end this dictation. If you have any questions about what I've included in this tape or any questions about other aspects of the chapter, please contact me and I'll be glad to assist. End of tape.